this might happen. The joint representation, simultaneous representation is enough, because in Berger versus Kemp, the Supreme Court assumed what we would call Rule 1.10 imputation, that law partners, that it's the same as one lawyer representing, but simultaneous representation by a single lawyer in a case where they might have adverse interests wasn't enough. The multiple representation is not by itself a basis for disqualification. In fact, I think in Wheat versus, well, both in Mickens versus, in actually all three of those cases, cite back to an opinion by Justice Frankfurter in Glasser. It was an opinion in dissent, but the majority adopted that point that that a common defense might often be better strategy. And so the Constitution and the existence of an actual conflict does not turn on even just those opportunities. It takes more, and we are speculating. The other thing to remember here, Your Honor, is that an erroneous deprivation of counsel at this point. I mean, the state is concerned about ensuring that any judgment in its favor is stable, but an erroneous deprivation of counsel at this point, no matter what quality of counsel Mr. Williams received at trial, if he's convicted, there's no showing of prejudice for reversal. He was denied his chosen counsel. His chosen counsel, with whom he has a long-standing relationship of almost a decade, his chosen counsel who's intimately familiar with his business and affairs, whom he trusts, who has advised him in a number of matters, and who is simply not replaceable, even by other competent defense counsel, because he has been chosen. And even if the court were to find a conflict, it still has to balance the risk of the need for ethical conduct and the need to ensure the fair administration of justice against those concerns for the defendant. Even if we got there, even if the court were to find that the state had substantiated its claim, which we still say it doesn't. I'd like to loop back to two other points. As far as substantiation goes, Ms. Rosenwasser mentioned Edwards versus the state, the case out of the Court of Appeals, and it grew out of the Tallapoosa Circuit. And there, the public defender, the appointed public defender, had previously represented a defendant in represented then a defendant in a child molestation matter, and the state's principal witness was the mother of the child, whom the public defender under previous practice represented, I believe, in a divorce matter. Not a divorce from this defendant, but a divorce matter. And there, the public defender himself put on the record that he was aware of confidential information that would affect his cross-examination. And that affirmative representation was enough to justify the Superior Court's disqualification of counsel, even though the defendant wanted to go on with his chosen counsel. The other thing, though, is completely different from what we have here. In Edwards, the witness, the former client, had offered no waiver, so there was no waiver of confidentiality, and the court did not accept upon investigation the public defender's representation that he could navigate around the confidential information. So he was trying to be ethical, but he conceded on the record that his representation would be affected. So there is a basis to infer that.
That's a little different because, still under rules, all of us have an affirmative duty to, if a conflict develops and the potential that at the time the conflict is present to raise that to the trier of facts. So he was doing what he was supposed to do.
Oh, absolutely, Your Honor. But the point is, when the issue went up on appeal, the court was not wrong in granting the mistrial because it concluded that he could not be effective, but there was substantiation. There was evidence in the record that would justify that conclusion, as opposed to, say, Lewis, where we were speculating, or even in...
But doesn't that scenario demonstrate anybody who's been practicing criminal law for a while will tell you that conflicts often develop kind of at an instant. meaning that when these equities change or evidence is made available, that's when we're people that think there's not a conflict then develops, and then the court has to take other actions to either salvage or even to sometimes to re-engage the proceedings because somebody is pulled out because a conflict has developed through representation. So isn't that something that may potentially happen in this particular case, given the fact that you got 28 folks, different equities, and I mean, I know you said this is speculation, the state hasn't offered anything as of yet, but isn't that part of the issue that the court as the arbiter and keeper of the process should be worried about?
I'm not saying the court should not be concerned, Your Honor. It is potential. Potential, however, does not mean serious potential, which is what wheat requires. And
you don't think it's serious potential that we've got 3 people that are that have predicates that are in the indictment?
No, Your Honor, I don't. Not at this point. Not without more. And
what would you consider to be more then?
An actual attempt to make an offer. If there were an actual attempt to make an offer, if the state said, all right, we're making an offer, and the court were to determine it wasn't simply to manufacture the conflict, which is another point it has to consider here under Weed. If the court were to actually make the offer, maybe we'd be in a different posture. We need to do something to address the conflict and perhaps change the posture of one of the defendants from present to former, and that's something that Mr. Steele would have to deal with. But that, or especially with Mr. Blaylock. But
doesn't that pose a problem for the people who are that Mr. Steele has represented in the past, in particular Mr. Blaylock, from even evaluating an offer or even being available to discuss that without the worry that the current client is going to potentially roll on them, or got the role being given adverse testimony to against their interest?
Well, let's take that for a second, Your Honor. So let's say an offer is made to Mr. Greer or Mr. Arnold or Mr. Stillwell Jackson. I know his name is Stillwell in the indictment. I think the waiver indicates that the name is properly Jackson. But let's say that offers are made to them. They're going to be made through other counsel, and other counsel are going to consult with him or with them. And other counsel are going to advise them of the risks and benefits, and they aren't going to be able to get, and they aren't going to have a claim because they have other independent counsel advising them that the representation they got in this case was adverse. The only person who even might, and we're not there yet, the only person who even might is Mr. Blaylock, whom Mr. Steele represents in a different, though factually connected matter. We don't know if there's going to be an offer there. We don't know if the state's going to be willing to give up some or all portion of its of the motion for of the judgment it has and that it is now trying to defend against an appeal. But it just simply hasn't happened yet. And we also let's assume that assume for the sake of argument that Mr. Steele withdrew from that representation. Mr. Blaylock had other counsel. The counsel he had then could advise him.
He hasn't done that yet.
He hasn't done that yet.
Right.
But again, if the state is speculating, well, this might happen. We might make this offer. Mr. Steele might withdraw. He might have other counsel. He might be properly advised. If we're talking about protecting the right and the interests.
How can he represent the interests of Mr. Blaylock, who's charged in Acts 76 and 74, 76 and count 1, and the interests of Mr. Williams at the same time?
The state has conceded they're not presently adverse. It concedes that in the motion, Ms. Rosenwasser indicated today. It only indicates that they might become adverse. If they become adverse, then Mr. Steele would be the first person to come to the court and say, oh, now we have a problem. I need to either withdraw from one representation. I need to do something. I point the court back to the United States versus Harrison. At the end of the district court's order, the court recognized that there was a potential for conflicts to arise, and it reminded counsel of their obligation to inform the court should the equities change, should the conflict or the serious potential for one manifest. And in that instance, Your Honor, steps would have to be taken, but that one does not mean steps could not be taken to preserve make sure that everyone had the right to effective assistance of conflict-free counsel, and in addition, that any judgment obtained against them would be sound, because when they received the advice and made the decision to plead or not, they would have had the benefit of independent counsel who didn't have these problems. It simply doesn't mean that. But all of these things could happen, and it would still protect the judgment and wouldn't undermine the fair administration of justice. We just don't know yet.
Okay. Anything else?
I would come back to, Your Honor, that even if the court were to find the state has substantiated a conflict, there is a serious potential for an actual impairment of Mr. Steele's representation that could not be cured through withdrawal or something else. When it comes down to balancing the equities, we have to talk about what Mr. Williams loses in this case. He loses an excellent lawyer, one whom he believes to be the best of the best, and rightly so, and by Your Honor's own acknowledgement, and one who knows him for 10 years, who has an expertise about his life and affairs that is simply irreplaceable, and who is already, and there is also going to be a significant financial cost and loss of effort that's already been put in, and all of that counts, Your Honor. So even if the court gets there, then it still has to balance the equities before making a decision. And the burden is still on the state to show that the extraordinary remedy of disqualification is appropriate. And lastly, Your Honor, I have, looping back to the beginning, I have no problem with the court making the inquiry that's described in Taylor, because more than anything else, that would insulate a potential judgment against reversal on these grounds, because once the waiver has been placed on the record, none of these defendants could claim they received the ineffective assistance of counsel, because they would have induced the error, and induced error is an absolute bar to reversal.
I will tell you that from what you both have stated, I will, pursuant to Taylor, go ahead and probably do an in-person waiver. I think that would be prudent under the circumstances, and I'll set that up as soon as possible. So, but I definitely, as part and parcel of this particular analysis, would want that on the record, regardless of what I ruled. Okay. All right.
So I guess that brings us to the question: if the court's not ruling today, Mr. Steele had planned to argue the bond motion. I know there's no present adversity.
Well, here's the thing. I have to resolve the issue of the counsel first, as I mentioned to Mr. Steele, before I do the issue of bond. Because he has chosen counsel for Mr. Williams. Yeah. So I believe I have to resolve that issue to begin with. But let me kind of ponder on that to begin with, okay? Yes, Mr. Steele.
May I speak, Your Honor?
I thought you were represented by counsel now. You can't have a twofer, sir. It's one or the other, all right?
I'd like to answer some of your questions, if it's okay with the court, factually.
All right.
Thank you, sir. And good afternoon, Your Honor.
Good afternoon.
Your Honor, I heard you ask multiple times the predicate acts in the indictment. How do the court deal with that? I need you to understand the following, please. Mr. Arnold, I never represented Mr. Arnold. You will find nothing that I have ever defended that man. I have never spoken with him about his case, that there are predicate acts in this indictment.
I want to ask something. Does the state want Mr. Steele to testify about this? Because one of the things about these types of motions is there has to be some evidence. So if you're gonna, I mean, I know you're an officer of the court. You would not tell me anything inconsistent with that, but that is something that I would have to. Part of my determination has to be based on evidence that has been given in this case.
Your Honor, the state's position is so I had planned when I went back up to ask to just have the court take judicial notice of the exhibits I had already admitted. However, if Mr. Steele would like to testify, I would just simply like the opportunity to ask him any questions I might have, but I don't have an objection to him testifying on his own behalf right now, and I can ask him some questions afterwards.
Mr. Steele, I've had one of these go up before, and that's part of what was the other lawyer that raised the issue did ask those particular inquiry under oath. Do you have an issue with that, sir?
No, sir.
Okay, all right. Let me go ahead and swear him in. Raise your right hand, sir. Do you solemnly swear affirm the evidence you'll give me in the case down here should be the truth, the whole truth, nothing but the truth, so help you God, so affirm?
Yes, sir.
Okay, all right, go right ahead.
With regards to Mr. Arnold, there was a shooting at Lenox Square Mall. I was at my office. I received a phone call, not from Mr. Arnold, and I don't know who it's from, but it's one of his supporters. It was either a manager or a female friend, is my memory, and said, the police are all over the mall. We're afraid that they're looking for Mr. Arnold. Would you please find out if there's a warrant for him so he could turn himself in? I was busy I was either on trial or doing an appeal. It's a long time ago. There's no file in my office. I asked another lawyer in my office, not affiliated with me, named Travis Galan, G-L-A-N, to go to Lenox Square Mall and find out if you could find out who is the police officer involved. Is there anything for Mr. Arnold? Travis Galan went to Lenox Square Mall. He got the name of an officer. I contacted the officer. I told the officer that I was contacted. If Mr. Arnold needs to turn himself in, if there's a warrant, then he would do so rather than the police have to potentially, I'm not saying any of this would happen, but go and waste resources finding the man. The officer told me, meet me at the police precinct. It's not far from the Honorable Don Samuel's office. I was there, I remember, very late, 10 o'clock, 11 o'clock at night. The officer finally either showed me a warrant or gave me his word there's a warrant. I called a supporter. I said, there's a warrant. That's it. In the records, when the state raised this, they attached one page of an unsworn statement of a witness that says that I supposedly, and it's worded where you don't really understand it, but I supposedly made a statement, a confession on behalf of my client. I never spoke with Mr. Arnold in my life about that case.
is on all of us. That's why 11 Alive is committed to sharing diverse perspectives, exposing injustice, and finding solutions. Voices for Equality, sponsored by Georgia Power and our other partners.
The 11 Alive Storm Trackers. It's how you see weather happening now across Metro Atlanta.
These severe storms are now closing in.
We could be talking about damaging winds, hail, and
How you can plan ahead by knowing what's coming overhead.
Heavy storms are rolling in.
Expect pop-up thunderstorms and rain all day long.
And how you'll be weather ready wherever you are.
We expect at any moment a tornado warning could be issued.
The 11 Alive Storm Trackers. It's how you'll be prepared and stay safe. 11 Alive Morning News.
We began with breaking news this morning.
Is where you know what's happening now.
11 Alive is live on the scene.
Where you can confidently plan ahead
This severe weather is intensifying.
by knowing what's coming overhead. And where Atlanta's traffic expert
We've seen delays almost 30 minutes worth of
helps you get there on time, every time. 11 Alive Morning News is where you start the day prepared. Watch weekdays 5 to 7 a.m.
If you see breaking news or severe weather near you, snap it and share it using Near Me on the 11 Live News app. Want to verify if something's true or false? Record your question and send it. Download the 11 Alive News app to use Near Me.
11 Alive News at 11 p.m. is where you find out what's happening now across Metro Atlanta.
we begin tonight with breaking news out of Cobb County, where a neighborhood is now.
Where you stay a step ahead of severe weather.
Our storm risk has now been upgraded to a...
And the only place where you can verify fact versus fiction.
11 Alive can verify that claim is false.
11 Alive News at 11 p.m. Where you end the day ready to take on tomorrow.
Weather can't run from the 11 Alive Thunder Truck. A mobile weather center with the power and speed to chase down the strongest storms and bring you on-the-ground conditions. The 11 Alive Thunder Truck, sponsored by Landmark Dodge. Fighting social inequality is on all of us. That's why 11 Alive is committed to sharing diverse perspectives, exposing injustice, and finding solutions. Voices for Equality, sponsored by Georgia Power and our other partners.
The 11 Alive Storm Trackers. It's how you see weather happening now across Metro Atlanta.
These severe storms are now closing
We
in.
could be talking about damaging winds, hail, and
How you can plan ahead by knowing what's coming overhead.
Heavy storms are rolling in.
Expect pop-up thunderstorms and rain all day long.
And how you'll be weather ready wherever you are.
We expect at any moment a tornado warning could be issued.
The 11 Alive Storm Trackers. It's how you'll be prepared and stay safe. 11 Alive Morning News
We began with breaking news this
is
morning.
where you know what's happening now.
11 Alive is live on the scene.
Where you can confidently plan ahead
This severe weather is intensifying.
by knowing what's coming overhead. And where Atlanta's traffic expert
We've seen delays almost 30 minutes worth of
helps you get there on time, every time. 11 Alive Morning News is where you start the day prepared. Watch weekdays 5 to 7 a.m.
If you see breaking news or severe weather near you, snap it and share it using Near Me on the 11 Live News app. Want to verify if something's true or false? Record your question and send it. Download the 11 Alive News app to use Near Me.
11 Alive News at 11 p.m. is where you find out what's happening now across Metro Atlanta.
we begin tonight with breaking news out of Cobb County, where a neighborhood is now.
Where you stay a step ahead of severe weather.
Our storm risk has now been upgraded to a...
And the only place where you can verify fact versus fiction.
11 Alive can verify that claim is false.
11 Alive News at 11 p.m. Where you end the day ready to take on tomorrow.
Weather can't run from the 11 Alive Thunder Truck. A mobile weather center with the power and speed to chase down the strongest storms and bring you on-the-ground conditions. The 11 Alive Thunder Truck, sponsored by Landmark Dodge. Fighting social inequality is on all of us. That's why 11 Alive is committed to sharing diverse perspectives, exposing injustice, and finding solutions. Voices for Equality, sponsored by Georgia Power and our other partners.
The 11 Alive Storm Trackers. It's how you see weather happening now across Metro Atlanta.
These severe storms are now closing
We
in.
could be talking about damaging winds, hail, and
How you can plan ahead by knowing what's coming overhead
Heavy storms are rolling in.
Expect pop-up thunderstorms and rain all day long.
and how you'll be weather ready wherever you are.
We expect at any moment a tornado warning.